Hi, I'm Shan Wu with the Under Color of Law hot take on the end to the Jack Smith federal cases. So as I posted today, not unexpected, but sad and infuriating nonetheless, Special Counsel Jack Smith and DOJ have dismissed the two federal cases against Donald Trump. So a few important things to consider here and to talk about, what's left to do, what should we learn from this going forward. Let's take a look at the judge's opinion, Judge Tanya Chutkan's opinion. We'll put up excerpts from the opinion. Let's examine them together. So the government has moved to dismiss the superseding indictment without prejudice. Chutkan points out that you need the leave of court to dismiss the indictment. And one reason you need leave of court is it's actually meant to protect defendants from being willy-nilly pushed about like a ping pong kind of ball, because we're going to threaten you and charge you, then we won't charge you, and then we'll charge you again. So that's why you actually need the court to weigh in to make sure there's not any kind of bad intention on the part of the prosecution. Naturally, court doesn't find that here. Trump's lawyers, big surprise, did not oppose the motion to dismiss, and they grant it without prejudice. So there's a strong presumption in favor of granting dismissals without prejudice, and it's somewhat unusual to say that there's prejudice that's going to be granted. And the difference there is if you grant something as dismissed with prejudice, what they mean by that is the prejudice is you can't bring it back, it's forever gone. Without prejudice means you can bring that case back again. So there are lots of times something may be dismissed without prejudice. There are technical errors made or along that nature. This is obviously historically a very unique situation, but it is without prejudice, so we'll talk about that. One thing to remember is that it's not the same as double jeopardy. That may be something that some folks will start to talk about, particularly in MAGA world, that you can't ever bring this case back. It's not double jeopardy because legally you require jeopardy to, quote, attach, unquote, and that only happens after a jury gets sworn in our system. So that didn't happen here. It has nothing to do with double jeopardy. It hasn't actually been tried twice. Trump's lawyers, Trump's whole aim here was to delay the case until he was elected. That's counting on him being elected, so they could take advantage of the DOJ policy against prosecuting sitting presidents. Now, that's a terrible policy in my view, because first of all, it's never been needed, so they have this policy that really has not had to have been used, and you would never need it unless you had a president who appears to satisfy certain criminal standards. So those standards are quite high, right? You need there to be a finding of probable cause, not just by a prosecutor, but by a judge. It has to be a grand jury. All that, you have to prove it beyond a reasonable doubt. But instead, what DOJ did was they created a rule which is designed, it seems, to protect the very category of person that the law should be applied to. So that's a very bad rule to have. Nonetheless, that's a rule within the Justice Department. It's not law. It's a rule that they want to follow. Now, the chance of the cases coming back, even though it's dismissed without prejudice, very, very poor. 4 years is a very long time to put a case on ice. A lot of bad things happen to it. It deteriorates. Not to mention that Trump himself could attempt to pardon himself. He could simply, with his new DOJ, try to do it with prejudice. So really, the likelihood of it ever coming back is very poor, although it's very important to note it theoretically could happen. Very different than if a sentencing had been postponed or imposed with the execution of the sentence suspended, as could happen in the Manhattan case. But here, we never got to trial. In the Florida documents case, the appeal is going to be dismissed as well, but the other defendants in the appeal will continue to go forward, and if the appeal is successful, they'll still get charged. Now, of course, Trump can pardon them or otherwise order the cases dismissed once he takes power and has his own DOJ. So frankly, following the logic of that, I'm a little bit surprised that DOJ and Smith didn't just dismiss the other defendants as well, because it's the same thing that's going to happen once the Trump regime takes power, is going to get dismissed. They probably didn't do that because they're still kind of following some idea of the semblance of normalcy, which is they think there's a reason the cases against Trump have to be dismissed. He's the president-elect. Doesn't necessarily apply to the other people. Okay, we'll talk more about this normalcy idea in a moment. Now, one thing that's also too important to remember is this is not a decision on the merits. Smith's motion specifically says nothing's changed in their position about the evidence or the merits. It's just that the circumstances have changed, meaning Trump was elected. That's going to be very different than what we all hear from Trump world MAGAs. Trump's spokesman predictably says, we'll put that up for you, quote, today's decision by the DOJ ends the unconstitutional federal cases against President Trump is a major victory for the rule of law. That's Stephen Chung, who you're going to get very tired of hearing from in the next 4 years. While I agree with him, it's a major victory for Trump. It has absolutely nothing to do with the merits against him in the case. It was a very strong case against him. It's not unconstitutional. And really, it's not at all a victory for the rule of law, of course. It's really a victory for raw political power, unrestrained by the law, which allows the political victor to make the law. So take a listen to a question posed here to Representative Dan Goldman of New York, who was one of the lead counsel in the first impeachment of Trump. Take a listen to this.
Congressman, you know that the American people were well aware of the charges that Donald Trump was facing in this case and several others. What do you make of the argument that they essentially served as a jury, and by re-electing him and now making him president-elect, they have weighed in on these matters?
So the answer to that question is no, because the criminal cases take place in the courtroom within the justice system, not subject to a vote. There's a reason why the rule of law isn't just the will of the voters, because that's mob justice. So let's take a pause for a moment, because we usually think of mob justice as going after an accused without safeguards, like a lynch mob. But it actually works the other way around too, which is what's happened here, which is raw political power was allowed to run unchecked by any rule of law. So this is also mob justice in the sense of it's just the unchecked power of the majority at work. Now let's listen to Representative Goldman's actual answer to this.
Just right off the bat, your reaction to Jack Smith announcing that he will file to dismiss the charges in the election subversion case against former President Trump.
Well, look, I certainly understand why he did it, given the Department of Justice policy that you cannot prosecute a sitting president. I think it is a shame for justice in this country. It establishes that Donald Trump is above the law. The Supreme Court put him above the law in that opinion that Paula just mentioned. But now he appears to escape full accountability for what were crimes charged by a grand jury. And I would just add one other thing that we ought to pay close attention to. We cannot normalize the fact that Donald Trump, as the president-elect, should not be held accountable for crimes that he committed before. If he were to have fired the special counsel, that would be a gross abdication of the independence of the Department of Justice. And if the shoe were on the other foot, for example, and Joe Biden were to have fired David Weiss, who clearly had a politicized investigation because the House Republicans effectively scuttled a plea agreement, everyone would be up in arms. So let's make sure that we don't normalize Donald Trump's political partisan behavior that has no place under our rule of law.
He is right. It was normalized, but not in the courtroom. It was in the campaign, in the media coverage, and of course, in the Attorney General's approach. Again, I am not claiming that Garland is corrupted or incompetent, but it appears that the approach that was taken was too deferential to political power. Not the usual idea of corruption or listening to the person in power telling you do it this way, but in the deference granted to the political institution. The failure to recognize that institutionalists can be as supplicant to political power as somebody who simply an acolyte is to being told what to do. What's left? The Manhattan case, maybe somewhere down the road, the Georgia case, the state cases. And for the Georgia case, at least, if Trump tries to do a pardon and dismissal, a little bit harder to do. They'll probably make these arguments about supremacy clause and all that, but it's going to be harder to do. Another thing that's important for us to understand is to make sure everybody understands this was not a decision on the merits. It really has to do with the circumstances changing. He's now the president-elect. It was anything but a decision on the merits. Let's think about this, I'd suggest, as having been a stress test for the system. And it failed. Okay, let's make no bones about that. It was a failure. But a failure of a test doesn't mean you can't ever continue. People fall down, they get up. Systems have failures, they continue. That's what the takeaway is here. This was a stress test. It was a test that our system failed for a couple of reasons. One, possibly, Attorney General Garland, DOJ, started too late. There just was not enough time to do this because they had some delay before they started it. Number two, the Supreme Court really added that delay and made the whole trial impossible. Those were failures. We need to learn from those failures and correct them. That's it for now. We'll talk to you soon. Thanks again for the comments and replies. They really are really helpful to have. Make sure you do subscribe to the channel, and we'll talk to you later.
In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.